Hello, everyone, and welcome. Our names are Kate and Adelaide. We are students at Western Law School, and we're working for the summer at Community Legal Services. Today, we will be presenting a guide to renting in Ontario. We designed this presentation with new Canadians in mind to help you navigate the law around housing and landlord-tenant disputes in Ontario. We hope that this presentation will give you a better understanding of the law so that you can feel informed and protected when renting. We hope you find this guide helpful and wish you the best of luck establishing your new home in London. We will begin our presentation with an overview of key terms and definitions by Adelaide to better understand the language often used in leases and housing law. We will then move into a detailed explanation of Ontario leases and what your steps should be before you even sign one. We will explain what the standard terms of a lease are, including what is allowed and not allowed to go into one. We will discuss what your tenant rights and responsibilities are, what your landlord's responsibilities are, and explain how to terminate a lease. Finally, we will discuss evictions and landlord-tenant disputes.
So I'm just going to go over some key terms that are going to come up throughout this presentation. So the first term is tenant. A tenant is the person who pays rent in return for the right to occupy a rental unit. The landlord is the owner of the rental unit who permits the tenant to occupy the unit in exchange for rent. The Landlord Tenant Board, or the LTB, is the organization that is responsible for resolving disputes between tenants and landlords. The Residential Tenancy Act, or the RTA, is the law in Ontario that sets out the rights and responsibilities of landlords and tenants. There are some living situations that are not protected by the RTA, such as hotels, trailer parks, living accommodations provided by educational institutions, so colleges or universities, and units where a kitchen or bathroom is shared with either the owner or a relative of the owner. An eviction is the legal process where a landlord can apply to remove a tenant from a unit. Rent is the amount to be paid, usually monthly, to the landlord for the right to occupy a rental unit and obtain any services or utilities that has been promised by the landlord. Termination is the ending of a lease, which can be done by the tenant, by the landlord alone, or consensually between them. Harassment is annoying or provoking comments or conduct which is known or should be known to be unwelcome. The tenancy agreement or the lease means a written, oral, or implied agreement between a tenant and a landlord for the occupation of a rental unit. Utilities usually refers to heat, electricity, and water services in a unit. Utilities may be included in the rent, or tenants may be responsible to pay these bills themselves. And finally, a deposit is an amount of money given to the landlord when a lease is signed. The landlord will typically ask for a deposit for last month's rent. So I'm going to go over some best practices while looking for housing. So these are some things you should be cautious of while in the process of looking for housing. So first, any unit that has rent that is very low is likely too good to be true. In the context of rent geared to income housing, below market rent will make sense. Otherwise, this is something to be cautious of. Some landlords may ask for a deposit to secure a unit before a lease is even signed. This should not be done. Once the landlord is given that money, it will be hard to get that money back if there is an issue that arises. And you should expect to pay a deposit when a lease is signed, but never before. It is always best to view the unit before signing a lease. A landlord could use old pictures, pictures of completely different unit, or omit pictures of damage from the listing. It is also possible that a person advertising the rental unit may not even own it, and it may be an attempt to commit fraud. So it is always best to see the unit in person to spot these issues for yourself. When paying when rent or deposit, you should never use cash. It is always best to use checks or e-transfers so there's a trace of rent being paid. You can also request a receipt from the landlord as well. You should never share your social insurance number with your landlord. There's a possibility of identity theft if this is shared. A landlord is allowed to conduct a credit check before choosing a tenant, but they should never ask you for your specific bank account number. And finally, if there are any tenants in the unit, you can try to talk to them about the landlord and their rental unit to see how responsive the landlord is when issues do arise. And if there are any problems in the unit that a landlord is not likely to tell you about, you can also ask the tenants about the neighbors and the neighborhood to see if there are other things you should be concerned about.
I'll now briefly go over discrimination in the tenant selection process. So be aware that a landlord might specify in an advertisement the type of tenant that they're looking for. However, a person cannot be refused housing based on a protected aspect of their identity under the Ontario Human Rights Code. This means that landlords are not allowed to select tenants or deny tenants based on the tenant's race, color, ethnic background, religious beliefs or practices, ancestry, including individuals of Indigenous descent, place of origin, citizenship, including refugee status, sex, including pregnancy and gender identity, family status, marital status, disability, sexual orientation, age, or receipt of public assistance. These groups are protected under the Ontario Human Rights Commission. If you are explicitly discriminated against, you may be able to bring a claim to the Human Rights Tribunal of Ontario. If you're having other housing issues on top of discrimination, you may also prefer to bring a claim at the Landlord and Tenant Board, which can also deal with matters of discrimination. We'll now discuss more about what is a lease and what goes into one. So as discussed earlier by Adelaide, a tenancy agreement is a written, oral, or implied agreement between a tenant and a landlord for occupancy of a rental unit. Your lease will be a written tenancy agreement that must include certain elements. All leases must follow Ontario's standard lease for rental housing. So any lease that you sign should be based on this standard document. That's mandatory for all leases signed on or after April 30th, 2018. The lease should include information about your landlord and tenant rights and responsibilities under the RTA. It should be written in language that is easy to understand. Your name should be on your lease. If your name is not on your lease, then you are considered an occupant and not actually a tenant. So you are entitled to far fewer protections. Your lease should specify how much your rent is and when it's due and how it's due. So by e-transfer, check, etc. It should specify whether or not your utilities are included. So that would include parking or other amenities. Your lease should make clear any rules or terms about the rental unit or building. For example, around smoking. However, as explained further in this presentation, not all rules and terms that a landlord may include in a lease are allowed and may not all be enforceable. Your lease should also identify what your rights and responsibilities are as a renter and what your landlord's responsibilities are to you. So it should specify who is responsible for unit maintenance. For example, are you or your landlord responsible for cutting grass, shoveling snow, repairs, and when your landlord is allowed to enter your unit? So here is an example of a standard lease in Ontario, and highlighted in yellow are all of the key elements you should ensure are on a lease that I'll go over step by step. So the first element is the parties to the agreement or the lease. This section will have the names of the landlord and all tenants who are agreeing to the tenancy. Although if you are renting with roommates, it's possible that you could all have separate leases rather than one joint lease. Regardless, you need a lease with your name on it and your landlord's lease. or your landlord's name on it. Rental unit. So this section includes the address of your rental unit and includes if there are any parking spaces and where they are. Contact information. This is where your landlord should provide their contact information, specifically the address where you can give notices or documents to them. Your landlord may also provide the email address or phone number of where you can contact them. The term of the tenancy agreement. This section specifies when your lease starts and when your lease may be up, and whether it is fixed term or month to month or week to week. Your lease should clearly state your total rent and when it is to be paid. For example, your rent is $1,200 and due on the first of each month, and should specify how it is to be paid, so check or direct deposit, and to whom. If you are sharing the unit with others or roommates, note that this section could contain the total amount for both of you, not just the amount each of you will pay. For example, if you each pay $1,200 a month, the total rent or lawful rent might be $2,400. Services and utilities. This section states which services are provided by your landlord and which are not. So gas, air conditioning, storage space, laundry, guest parking, internet, etc. And also makes clear which utilities are covered by your landlord and which are not. So electricity, heat, water. If these utilities are not covered, you may need to set up your own account to pay them. For example, you may set up an account with London Hydro. Rent discounts. This section specifies whether there are any discounts you will get. For example, a rent freeze, a promotional discount, or a small discount for paying your rent early or on time. The next are rent deposits. So if there's a rent deposit required, this section should state the total amount you must pay. This amount will then apply to the rent for the last month or last period of the tenancy. So for example, if you sign a lease from May 1st of one year until April 30th of the following year, and you're asked to put down a deposit up front, that deposit should end up going towards the April rent of your last month. A key deposit, so this specifies whether you must pay a deposit to cover the cost of any lost keys or remote access cards or devices if you don't return them at the end of your tenancy. Smoking. The section specifies whether smoking is allowed in your unit and any other rules around smoking in the residence. For example, it could say that smoking is prohibited in your unit as well as all common areas in your building. Tenants insurance, your landlord may require you to take out tenants insurance and then provide evidence of that. Changes to the rental unit. This section specifies what changes you may be allowed to make in your unit. So could you put things up on the wall, paint, add minor decorations, window coverings, etc. Maintenance and repairs establishes that your landlord is responsible for keeping your unit in good repair and compliant with health, safety, and maintenance standards. This section identifies that you are responsible for repairing damage that you may negligently cause and sets out any cleaning your landlord might be responsible for. Assignment and subletting. This section establishes that you are permitted to sublet your unit or assign your lease with the permission of your landlord. The landlord cannot arbitrarily or unreasonably withhold consent for you to do that. Additional terms. So note whether your landlord is including any additional terms in your lease. This might include that the landlord will make certain repairs before you move in or include rules around the use of amenities or common spaces. But again, be aware that your landlord could include clauses here that are not legal and not enforceable, which will be covered on the next slide. Changes to the agreement simply clarifies after signing the agreement that all changes must be made in writing and with the consent of both landlord and tenant. and then signatures. So ensure your lease is dated and signed by you, your landlord, and any additional tenants. And there is just an overview of all the elements that should be part of your lease. So, what cannot be in a lease, or what are common void terms that a landlord might put in your lease agreement anyway? So, while there are many terms that your landlord can include in a tenancy agreement or lease, there are some that they are prohibited from including. Sometimes there may be terms that are included, even if the landlord is not allowed to include them, and they can be automatically void or unenforceable, even if you've signed the lease. So here's some common ones. No pets clauses. So if you tell your landlord that you have a pet before you've signed a rental agreement or a lease, the landlord can refuse your application. However, after you've signed a lease, a landlord cannot evict you simply for having a pet, even if the lease has a no pets clause. The only reason why you could be evicted because of your pet is if the pet causes a problem, impacts the reasonable enjoyment of other tenants. Um, for example, if your pet is causing severe allergic reactions, is making unreasonable noise, is dangerous, or is causing damage. Note that some cities may also have rules around owning animals in their bylaws, and condos may also make their own rules around pets. No guest clauses. Generally, landlords are not allowed to stop you from having guests over and should not be putting this clause in your lease. If they do, it's likely void. It is your right as a tenant to host guests and have your family, friends, or partner come over, including overnight, as long as your guests do not cause damage, commit illegal acts, or cause a disturbance. Your landlord generally cannot evict you simply for having guests over. Ensure that your landlord is not including deposits or fees to secure the unit or any other kind of fee that is not allowed under the RTA outside of a standard deposit or a key deposit, and then requiring you to pay for repairs that the landlord should be responsible for paying for. So be suspicious around those sorts of hidden fees or repair costs. Again, if there are any clauses you believe are illegal and should not be enforced, even if you've already signed the lease, be sure to speak to a lawyer. If your landlord attempts to evict you because you've broken a clause that turns out to be illegal, you can and should challenge your eviction by applying to the LTB. We'll now discuss what your landlord's responsibilities are to you. So, your landlord has a duty to repair broken appliances or damage in your unit that you did not cause. If, for example, your oven, toilet, dishwasher is broken, there's a leak, or you find damage in your unit after you move in, your landlord must fix this. They must fix it even if it was present when you moved in. Your landlord must provide vital services and make available the utilities covered in your lease, even if you still have to pay for them. So, utilities referring to heat, electricity, and water must always be functional in your unit, even if you have to pay to use them. Vital services refer to what must be available to you. So hot or cold water, fuel, electricity, gas, and heat during the part of the year where it's required. Ontario has very cold winters, and cities have laws around when your heat must be on. In London, your unit must be heated to a minimum temperature of 20 degrees Celsius from the 15th of September to the 15th of June. At all other times, it must be a minimum temperature of 18 degrees Celsius. Your landlord may not interfere with your reasonable enjoyment of your unit. You are entitled to privacy and access to your spaces and services. They may not harass you, intimidate, or interfere with you in the unit. They may not change the locks on you without providing you a new key. They may not enter your unit without notifying you unless it is an emergency. and they must accommodate any disability you have up to the point of undue hardship. Your landlord must also take action if your unit has become unsafe because of pests. So if there's mice, rats, cockroaches, termites, bed bugs, they must act swiftly and take care of those. If there's environmental or air quality concerns, so asbestos, mold, lead paint, or secondhand smoke, um, those are some common environmental problems, and your landlord has a responsibility to address these issues, even if the problem is originating in another unit. Landlords are also responsible for repairing leaks, or malfunctioning HVAC systems. And if your rights are being violated by your landlord, you may be able to take legal action against them.
So a common question is, can my landlord increase my rent? Landlords are allowed to raise rent after 12 months have passed since either the last rent increase or since your tenancy began. Every year, the LTB sets out the guidelines on the maximum that rent can be increased. For 2025, the maximum is a 2.5% increase in rent. And there are some situations where landlords are allowed to increase rent more than the guidelines in a given year. And to do this, they must get approval from the LTB. So if your landlord has increased your rent above the 2.5 maximum, then you can ask for proof that they have gotten permission to do so.
I'll now discuss what your responsibilities are as a tenant. As a tenant, you have 5 key responsibilities you should be aware of under the Residential Tenancy Act. The first is a responsibility for cleanliness. You have a responsibility to keep your unit reasonably clean. This includes sweeping the floors, keeping kitchen appliances, countertops, and sinks clean, and cleaning the bathroom, so the toilets and sinks. It is unlikely for you to be evicted because your unit is not clean unless a lack of cleanliness is interfering with the reasonable enjoyment of the landlord or other tenants or leading to other issues, including pests. You have a responsibility for the repair of damage if you have caused it. So generally, your landlord will be responsible for repairing damage in your unit unless the damage was caused by you or a guest being negligent. For example, if you or a guest was acting irresponsibly and put a hole in your wall, you are responsible for repairing that damage. You cannot change the locks on your unit without the explicit permission of your landlord, as they need to be able to access your unit for repairs. You may not harass your landlord, so you are allowed to contact your landlord, make complaints, and raise issues to them, and politely remind them that they may not enter your unit without notice if they unexpectedly show up at your door. But what you may not do is make any threats towards your landlord, scream at them, stop them from entering your unit if they've given notice or it's an emergency. If you do harass your landlord, this can be grounds for eviction. And finally, you have a responsibility to pay your rent on time and in full. And while this seems very obvious, failing to pay your rent or paying it late makes it much easier for your landlord to evict you. Also, be aware that you should keep paying your rent, even if you're having issues with your landlord or with your unit. Um, while your landlord is in the process of addressing these problems, or even if they're acting slowly, it is always in your best interest to continue paying rent so you cannot be later evicted for that.
So when living with other people, there's a chance that issues between tenants may arise. So if you and the other tenants are on the same lease, the landlord is not able to assist in any disputes, and you will need to try and resolve your problems between tenants. In this situation, if a landlord decides to take action, it will be against all tenants, as they are not able to deal with tenants individually. If the tenants are on separate lease agreements, you can talk to your landlord and they will be able to try and resolve the problems you are experiencing. And if the landlord wants to take action against the tenant individually, they will be able to do so. So that means that if the landlord chooses that they want to bring an eviction against one tenant while the others remain in the unit, that is a possibility. In a situation where you are living in a unit but have not signed a lease, you will be considered an occupant, as Kate mentioned earlier, and an occupant has limited to no rights under the RTA and can be asked to leave the unit if issues arise. And there are no ways to apply to the LTB. I'm now going to cover some ways a lease can come to an end. First, you can choose to end your lease when the fixed term is up. So, for example, if you have a 1 year lease, you can choose to end at the end, to leave at the end of that 1 year period. Next, it is possible to end a lease early before a fixed term is up if the landlord consents to it. If your landlord does not agree to end a lease early, there are still some possible ways to get out of that lease, which I will discuss later on. And lastly, there are some situations where landlord may decide to end your lease early. So first, how to end a lease when the fixed term is up. So, as I mentioned, many leases are for a fixed term, such as a 1 year period. And it is important to note that these leases do not end automatically when that fixed term comes to an end. Many leases will become month-to-month leases after that fixed term. And so to end your lease when the fixed term is up, you must give your landlord at least 60 days notice. So, for example, if you have signed a 1 year lease that begins on September 1st and you want to move out once that year is up, you will need to tell your landlord 60 days prior to September 1st. So that is at least by July 3rd. And to give notice, you need to fill out a N9 tenants notice to end the tenancy, and give that to your landlord within the time frame. And this form can be found online at the LTB website or at any LTB office. So moving out when your landlord does agree to end the lease early, and although it is not the norm to end lease before the fixed term is up, a landlord might still agree to this, and it might be in the best interest of both parties. If you discuss this with your landlord and they do agree, you can sign an N11 agreement to end the tenancy form. It is also acceptable to agree verbally, but it is always best to have everything in writing in case a landlord changes their mind. So if your landlord does not agree to end your lease early, you have a couple of options to get out of the lease. First, you can sublet your unit to another individual. Subletting happens when you find another individual to live in your unit and rent it to them on a short-term basis. With the rental period ending, with their rental period ending before your lease is up, you are still responsible for any damage that occurs to the unit. And if that subletter fails to pay rent, it becomes your responsibility to do so. An alternative to subletting is assigning your lease to another individual. Assigning a lease is best when you do not intend to return to the unit. When you assign the lease, you find a new tenant to take over your responsibilities as a tenant for the remainder of your lease period. The new tenant will also be able to stay in the unit past the end of your current lease if they choose to do so. In this situation, you no longer have any responsibilities to the landlord, which is different from subletting, where you are still responsible to the landlord. If your landlord refuses to allow you to sublet or assign your lease, you are then allowed to give your 60 days notice to end the lease. If a tenant or their child is experiencing domestic or sexual violence, they are able to give the landlord 28 days notice and can leave the unit. The tenant will have to show that they are experiencing domestic or sexual violence at the hands of a partner, spouse, or family member living in that same unit. They will also have to show that if they remain in the same unit, they will be at risk of harm or injury. A tenant can fill out an N15 tenant's notice to end my tenancy because of fear of sexual or domestic violence and abuse. Next, here are some few ways that a landlord can end the tenancy on their end. The first way a landlord can choose to end a tenancy is with no fault on the tenant. This happens when a landlord wants to do major renovations on the unit that cannot be done while a tenant is living there. This is usually when a building permit is required. They can also choose to end the tenancy if the landlord themselves, an immediate family member, or a caregiver wants to move into that unit. If a landlord tries to end the tenancy for either of those reasons, it is possible to challenge the eviction, which we will discuss in a few minutes. The landlord can also choose to end a tenancy for cause. This means that the landlord believes that as a tenant, you have failed to meet your responsibilities. Some common reasons why a landlord might end a tenancy for cause is if a tenant fails to pay rent in full and on time, if a tenant has caused damage to the property that they have refused to repair, if they are disturbing the use and enjoyment of the property for other tenants or the landlord themselves, and if the tenant is conducting illegal activity in the unit. So, what leads to an eviction? It is important to note that evictions do not happen right away. And if a landlord wants to end a lease and evict a tenant, there are multiple steps that need to be taken before a formal eviction can take place. So here's the process of an eviction. So if a landlord has decided that they want to proceed with ending a lease, they must first give a written notice to end a tenancy to the tenant. Included in this notice will be the date of termination and the reason for terminating the lease. This must be in writing. And if a tenant receives notice, they have a few options to address this. If they believe that the notice to end the tenancy has been done in bad faith, such as a landlord claiming to move into the unit for themselves,